viewers, welcome back to our channel Low Point. I'm Ms. Anisha Babu. Our today's session is on the frequently asked questions of motor vehicle insurance. We have our Supreme Court of India advocate on record, Ms. Priscilla Elizabeth Joseph, to clear our queries. So we have our first question. If a friend is given a lift in a car or scooter and they meet with an accident in which he suffers injury, then is a friend entitled to the road accident compensation?
Okay, we will consider two scenarios here. One is where your vehicle has only third-party insurance, and another scenario is where your vehicle has comprehensive insurance policy covering passengers. If the insurance policy covers only third-party liability, if your vehicle meets with an accident due to your fault, your friend will not get compensation from your insurer. However, if the friend files a case before the MACT against you alleging that accident occurred due to your negligence, then MACT will treat your friend as a third party and direct your insurance company to pay him awarded compensation. Second scenario is if your vehicle has comprehensive insurance policy covering passengers. In that case, your friend as a co-passenger is covered in your insurance policy in case accident caused by your mistake. It's important to note that in case accident is caused due to the fault of other vehicle, then both you and your friend injured out of the said accident are treated as third parties and both will be eligible to get compensation from the other vehicle's insurance company.
Moving on to our next question. If your minor child drives your car and injures a pedestrian, then is the pedestrian entitled to get a compensation from your car insurance company?
Yes, pedestrian is entitled to get compensation from your car insurer. However, the car insurance company has every right to recover the said compensation from the owner of the vehicle, because it is the responsibility of the owner of the vehicle to ensure that his vehicle is not used by a minor who has no driving license. So generally, MACT directs the insurance company of the vehicle to pay the awarded compensation to the injured third party, but at the same time authorizes the insurance company to recover the amount paid as compensation from the owner of the vehicle.
So let's dive into our next question. If a road accident is caused due to negligence of both parties, then will the victim be entitled for the compensation from the car insurer? Let's say you are driving a car and do not stop when the traffic signal is red and the pedestrian signal was also red, and in spite of which he was trying to cross the road and your car hits this pedestrian. In such case, both have violated the traffic rules. So will the victim be entitled to get compensation from your insurer?
Okay, this scenario is covered by the principle of contributory negligence, where victim is also negligent and has contributed to the occurrence of the accident. Therefore, his compensation gets reduced in proportion to his fault. It is generally observed that what could otherwise have resulted in a simple injury gets very complicated in the form of a grievous injury or even death, all because of violation of the law by the victim. Compensation amount in such cases will be determined on the basis of degree of negligence of the victim. If the MACT finds that the victim is equally negligent, responsible and has contributed to the accident just like the driver, then the victim would get only half the compensation.
So let's take a quick look into our next question. In your previous session, you stated that the compensation is computed by looking into the earnings of the injured. Suppose in a road accident, an housewife happens to get injured or die. How does the MACT calculate the compensation amount?
In the case of a salaried individual, it is easy for the court to consider his salary as a factor while computing compensation. However, in the case of housewife, there is no real income but only an assumed income. So, while awarding compensation to such a housewife, court employs different methodologies. Some of them are the income of the housewife is calculated as 1/3 of the income of a earning husband. For example, if husband is earning around rupees 30,000 per month, income of housewife is calculated as rupees 10,000 per month. Another methodology is based on the assumption that a marriage is an equal economic partnership, and in this method, the homemaker's salary is valued at half her husband's salary. So if the husband is earning rupees 30,000 per month, the wife's salary is calculated as rupees 15,000. Yet another method is replacement method. Had the homemaker not done any work and instead employed paid workers for the housework. Next method is the opportunity lost, which evaluates her income by assessing what she would have earned had she not remained at home. These are some of the methodologies adopted by the courts for evaluating compensation for a housewife.
So let's dive into our next question. As per the new Motor Vehicle Act 2019, what are the revised fine amounts for? Number 1, driving without license.
All of you will be shocked to know that in order for the fine amount to act as a deterrent in the minds of common public, the Parliament in their new amendment to Motor Vehicles Act 2019, fine amount have been increased considerably. So if you are driving without license, you will have to shell out rupees 5,000. Earlier it was 500 rupees. So here you can see a tenfold increase.
Number 2, driving without insurance.
If you happen to drive without insurance, the fine amount is increased to rupees 2,000. Earlier it was rupees 1,000.
Number 3, overload of passengers.
Overload of passengers. Let's say instead of 2 people, 3 people are on a bike, or in a car designed to carry 5 people, 6 to 7 people are inside. All these scenarios are like overload of passengers. It makes the vehicle less stable, the driver's control over the vehicle is diminished as he cannot accelerate as normal, overheat of tire, etc. This is a newly introduced fine of rupees 1,000 per extra passenger.
Number 4, drunk driving.
Drunk driving fine of rupees 10,000. Earlier it was rupees 2,000. Because there is a greater chance of causing accident in drunk driving resulting in injury or death.
Number 5, driving without seat belt or helmet.
Driving without seat belt in a car is charged rupees 1,000. Earlier it was rupees 100. Driving without helmet in a scooter was only rupees 100. But as per the Amendment Act of 2019, it is charged rupees 1,000, and also there is a temporary suspension of 3 months license.
Thank you for watching. See you next week with another legal video.